Good afternoon, everyone. My name is Maya Luria, and we are here with TMC for Seniors. It's been a few weeks, so I'm so happy to be back with our fall calendar. And we are going to start off this month by talking about managing your healthcare your way with advanced directives and really learning more about what that process is all about. I have Nicole Ralston, who is a nurse practitioner over at TMC Hospice, and she has a ton of information that she wants to share with us about how important it is to ensure that your directives are followed and that your wishes are followed. So welcome, Nicole.
Well, hi, thank you for having me.
So, Nicole, I'm going to go ahead and let you get started here. I'm going to put your presentation up and go ahead and jump right in.
Hi, okay, thank you. Again, my name is Nicole. I'm the nurse practitioner over at TMC Hospice, also known as Peppy's House. One of the things that I've always been passionate about, even prior to working hospice, was the idea of advanced directives. And that is probably the number one thing that will ensure that we get as much health care as we want or as little health care as we want, and particularly when it comes to end of life. So what does advanced directives mean? Because sometimes the term is a little confusing. So an advanced directive is actually the umbrella term, and it includes a healthcare power of attorney, a living will. Most recently, it also includes something called Physician's Orders for Life-Sustaining Treatment, or POLST. So an advanced directive is a set of instructions that you, as the patient or the principal, prepares in advance prior to becoming seriously ill or terminally ill, that will determine what your wishes are. And again, this should and can include any or all of the healthcare power of attorney, also known as MPOA or medical power of attorney, a living will, and then POLST. So what is a healthcare power of attorney? A healthcare power of attorney is a medical power of attorney, also known as, it's a legal document in which you name someone to be your agent, to make decisions for you if you become unable to do so. And that's really the most important thing, is that this only takes effect if for some reason you are unable to make your own decision, whether that is because of mental illness or dementia, or you're in a permanent vegetative state. But the idea is that a person's physician says or declares that you're unable to make your own medical decisions, and then they will defer to the MPOA that you have assigned. So in the event that you're unable to make your own decisions, your proxy or your MPOA has the ability to speak with your healthcare team and the caregivers on your behalf and make the decisions based on what you've written down in your living will or instructions that you gave them earlier. You can make these as specific as you want or as vague as you want, or general, but if your wishes in a certain situation aren't known, then your proxy will then make a decision based on what they know about you, your values, what you've decided in other situations. And when you regain the ability, so let's say you become conscious again, or you recover from the illness that has kind of taken you out of the ability to make your own decisions, you get to start making your own choices again. So then that proxy no longer makes the decisions once you are able to. That MPOA also ends when the person or the patient passes away. So you can assign somebody to be your MPOA, but they have no say in your final, what happens with your body after death, where you get cremated or where your cremains get spread, what happens with your account. This is only in regards to medical decisions. And it's very important that you pick someone that you think has the ability to carry out your wishes and make decisions based on your instructions. So if you think that you have a family member or a child that might become overwhelmed with the idea of making these decisions, that may not be the best person to choose. So sometimes what people do is they choose a backup person in case the first person is unable or unwilling to act on your behalf. And it's also sometimes a good idea. We find that a lot of family members choose their 3 children. So the 3 children are the MPOA. Well, if they don't agree, it can become very messy. So it's in the situation where you have more than one, the best approach is to put them sort of in a hierarchy. So if person A is unavailable or unwilling, then person B becomes the decision maker, and then person C, versus have them all 3 have equal decision-making power, because that sometimes is a little tough to get everybody on the same page. So what can the medical power of attorney decide? Well, they can decide what treatments you get, what medical facility you go to or what rehab facility you go to, which doctors, which specialists you might be able to see. They have the ability to go to court for you over whether or not you should receive or not receive certain medical treatment. According to this, it says you have the power to decide how your body will be handled after death. That is usually specified in your living will, and that is a decision that is given to, for example, in hospice, that is a decision that they would notify hospice of prior to your death. If you die and you haven't specified this out, again, the medical power of attorney at that point will no longer have any authority to say so. Technically, a living will is a legal document that trumps any individual decision of the power of attorney or trumps what the medical personnel have to say, but that doesn't always turn out that way. So there are many times where medical powers of attorney don't necessarily follow the letter of the living will. When that happens, it gets kind of gray, and you have to have people that are willing to advocate for you separately to get your living will adhered to. An MPOA also can establish visiting rights, as in who can and cannot see you in the hospital or at end of life. It's not a will. So a will really decides what happens to your financial resources and your estate after death. A living will is what happens with your body sort of prior. And it is a legally binding document, and it is set up in case to decide how you would like to be treated in case of a medical emergency. And the perfect example is resuscitation. So you may state in your living will that you do not want to be kept alive through artificial respirators or artificial feeding. The Arizona law requires that a living will be in writing, have very clear intent, it be dated, and be signed by an adult. An adult in Arizona is classified as anybody over 18. And it needs to be witnessed by at least one adult or a notary. So sometimes people don't set up a living will or a healthcare power of attorney because they think it has to be notarized, and it just seems sort of like this onerous task. But really, it can be witnessed by an adult, a single adult. But it is very important that the single adult not be a family member or not be a caregiver, someone that has a vested interest in your decision. So a living will prepared in another state is legal in Arizona, provided it was legal in the state of its origin at the time that it was established. One exception is Oregon and Washington, states where assisted suicide is legal. So a treatment that is legal in the state where the living will was initially established, if it's not legal in Arizona, then it cannot be put into action. And as I mentioned before, your healthcare power of attorney can't overrule any of the provisions, but they can supplement your wishes if something comes up that you didn't uniquely specify in your living will. A healthcare provider that makes good faith healthcare decisions based on what is determined to be a genuine living will is immune from criminal and civil liability for those decisions. So healthcare personnel, so a physician, a nurse practitioner, if they're making decisions based on your living will, even if they might go against what members of your family might might not agree with, they cannot be held criminal or civilly responsible for that. What are exceptions to this rule? Well, if the directions of the living will go against the conscience of the doctor or the individual medical service provider. So an example would be if you're at a Catholic hospital and the living will states, in the event that I'm pregnant, I want you to sacrifice the life of the baby to save my own. So that really then comes down to the rules and the policy decisions of that institution or the hospital. The directives also can be ignored if they would result in ineffective healthcare or ask a healthcare provider to adopt a healthcare standard that violates those standards of the provider, the hospital, or the medical institution. In the event that the provider or the medical institution cannot fulfill the terms of your living will, they are immediately responsible for informing your medical power of attorney and finding a provider or a facility where your wishes or your instructions can be honored. In the event that they refuse to help find a facility or a provider to transfer your care to, or that they keep you in this institution and continue to go against your wishes, the doctor or nurse practitioner may be liable for damages. There are, as I mentioned in the scenario where somebody's pregnant, there are very specific rules, and it varies from state to state, so I'm not going to get into it, that allow doctors and providers to ignore your wishes in the event that you're pregnant, unless you really very specifically have it spelled out in your living will. So a lot of the living wills that we see are very, very general, but if there are things that are particularly important to you, for example, if you've been diagnosed with a dementia or Lou Gehrig's disease, and that is, the decline ends up in such a way that it does not match with your view of a quality of life, then that's something you should probably think about putting in your living will, that in the event that this scenario comes up, I do or do not want treatment. So then the third thing is a physician's order for life-sustaining treatment, or a POLST. This is relatively new. And when I say relatively new, I would say between 5 to 10 years. It's really only made it to Arizona probably in the last 5 to 10. It's been in other states just about 10 or a little longer. And what it is, it's a portable medical order. So it's similar to a living will, but in this sense that it guides people in the decision-making, the POLST actually serves as medical orders that are to be honored by healthcare workers. So it's almost like having a specific set of prescriptions or physician orders that you carry with you from place to place. So in the event that you go into the hospital, you already have a set of orders that you would like them to follow. And that can include pain management, hydration, artificial nutrition, that sort of thing. It must be signed by a physician. And usually that is someone's primary care provider or oncologist, or someone that is very, very closely involved in the healthcare decision-making process. addresses what your wishes would be in case of an emergency, such as whether or not you'd want CPR, whether or not you would want to be transferred to a different hospital for a higher level of care. For example, would you want to go to a hospital that may provide emergency brain surgery, or whether or not you'd want to be put on a ventilator, or whether or not you would want to go to hospice care. And again, it must be signed by a qualified member of your healthcare team. And in Arizona, there is a national organization, and I put the website at the bottom, pulse.org, and then within the state of Arizona, you can download a sample form for orders that you, for a general idea of orders that would be included in this. So what happens when you don't have an MPOA? And this is probably what has, or a living will. And this is really the thing that has made me the most passionate about this topic, is when people have failed to either assign a decision maker or to put in writing what their wishes would be. It can become very, very murky. Studies show that 90+% of people want to pass away in their own home. They wouldn't want to be resuscitated in the hospital. And then of the people that die in the hospital, about 75% wouldn't have wanted that much treatment. They wouldn't have wanted to be resuscitated or put in the ICU, but because they didn't have it in writing, or because they didn't assign someone to make decisions, the kind of default is treat first and then start asking questions later. And if you don't have a living will and you have 6 children in the state of Arizona, your children have to agree. And I think, we all know from going out to dinner as a family, it's hard to get 6 people to agree on anything, particularly something as difficult or sensitive as end-of-life decisions. And, and then we also have scenarios where families are disenfranchised from other family members. So if you have 6 children and 2 of them are estranged, it becomes very difficult to get a hold of people and to get decisions made. And you can work around that when you can't find them, but it certainly slows down getting the care that you would want. So it is the responsibility of the healthcare provider to make every reasonable effort to locate a healthcare directive and a medical power of attorney. In the event that they cannot find someone, or they cannot find your healthcare directive, the healthcare providers should then make a reasonable effort to contact the following individual or individuals, and I'm going to show you in the next slide what the hierarchy is for these individuals. So it's the responsibility of the healthcare provider to then identify who is the surrogate decision maker. So the surrogate decision maker is what is considered the person making decisions in the event no medical power of attorney is assigned. So a lot of times you'll hear people say, well, as the patient's wife, you're the medical power of attorney, and that's not actually a true term. You're only a medical power of attorney if someone assigns you that role in writing. And you cannot give that role away. So if my husband decides that I'm the medical power of attorney and I become too emotionally fragile with what's going on to make that decision, I can't assign his brother as a medical power of attorney. All I can do is relinquish my role, and then it will go to the surrogacy hierarchy as to who then becomes the decision maker. I can't decide who becomes the decision maker for my husband if I'm not willing to do it. So it's important that you choose someone, and that you choose someone that you think would be willing to do it. So in the event that you don't choose somebody, you get a surrogate. And a surrogate has a order of priority in terms of who gets the first right of responsibility. The first right of responsibility is always the spouse. unless you are legally separated or divorced. And you would be shocked at how many people are separated but have not made it a legal separation, or have just drifted apart and not had a divorce, not had a legal separation. And believe me, that person will be expected to be your decision maker. So if your husband has run off with a tennis pro to Boca Raton and you haven't seen him in 6 or 7 years, but you haven't divorced him or you have not assigned a medical power of attorney, then your ex will be the one that's first approached to make a decision for you. And I think most of us would agree that the person that we want to make our decisions for us have a vested interest in following our wishes. So in the event that your marriage dissolves and you're not yet legally divorced, it's very important that you update or you assign a medical power of attorney. If there is no spouse, or that does not apply, or the spouse is not of adult age, but it then becomes an adult child. And again, that's a child over the age of 18. In the situation where the patient has more than one adult child, the healthcare providers or the hospital then tries to seek a majority of the adult children who are reasonably available. So that's where that scenario where you have 6 kids, 2 are estranged, then they try to get a majority of the 4 that are available to decide. And that, of course, would be 3 out of 4. And that can be difficult to get everybody on the same page, especially if they're not in the same city, because being geographically nearby doesn't count or doesn't apply towards being available, because we can, of course, talk on the phone. In the event that the children are of minor age or there are no children, it becomes a parent of the patient. And of course, I'm in my 50s. I have a parent that has Alzheimer's, so that would not be a good choice for me. So then at that point, it would drop down to a domestic partner. And this is a touchy situation, because if you've been a domestic partner for 15, 20 years, then by all standards, you're married. You're married in your heart. You're married probably in your mind, but they don't hold the same authority as a legal spouse. As a matter of fact, they're 4th in line. So if you do have a long-term domestic partner, you may want to go ahead and make them your medical power of attorney. In the absence of a domestic partner or parent, it then becomes a sibling. In the absence of a sibling, it becomes a close friend. And a close friend is someone that is an adult over the age of 18 that has exhibited special care or concern for the patient, or is familiar with the patient's healthcare views and desires. And so for some of our patients in hospice that are estranged from their family and don't have, to the best of our knowledge, don't have family, it winds up being somebody like their landlord or a pastor at their church, or a neighbor that they've lived next to for a long time. But that doesn't necessarily make it someone that really knows what you would want. In the event that a healthcare provider cannot locate any of the people listed in this surrogate decision-making tree, 2 physicians can, with the input of an ethics committee or with the input of other physicians, so like consultants on your case. So 2 physicians may get with the nephrologist or the pulmonologist or the ethics committee, and then they can make the decision regarding the end-of-life care. So whether or not to consult hospice, whether or not to give you a tracheostomy and put you on the ventilator, whether or not to resuscitate you. So then the very last ditch effort would be the decision of 2 physicians. I've included links to, well, not that you can access this, but if you want to copy it, links to forms where you can download your own medical power of attorney, living will, a post form, and it's quite simple to do. And in fact, one of the reasons that people state they don't have a living will or a healthcare power of attorney is because they think that it's a chore. And really, it's just usually a 2-page form unless you really want to put some time and effort into it. You don't need to have it notarized. You can have it witnessed by an next door neighbor or by your nurse or by your physician. Once you have these documents in place, it's important that you give a copy to your primary care provider, and then you bring the copy to the hospital if you were to go to the hospital, even if it's for something minor, because then it gets scanned in the computer, it gets documented on your file that you do have a living will and you do have a medical power of attorney. And in the event that in the future you go back to the hospital in an emergency situation, they know who to contact in regards to decision making for you. And if they don't have it in the computer, but your primary care has it, then they can provide it. So it's always a good idea to make sure that people, including your MPOA should have a copy of your living will. And it's a document that you should discuss with them, that you should say, well, I would never want to be resuscitated if this, and this happened, or I absolutely want everything done. Please don't let them pull the plug, or, just talk with people about what you want. Another reason that people don't get a living will or a healthcare power of attorney is that they think it's not going to happen to them. And there's no guarantee. You don't know what could possibly happen that would leave you without the ability to make your own decision making. And you don't need it until you need it. And by then it's too late to put that in place. And the third reason is because people think sometimes that it's a little bit grim, talking about, well, what do you want at the end of life? And what do you want? Would you want to be resuscitated? Would you want hospice? Would you want pain medicine? And it's really to do these documents, obviously is not going to make these things happen. But what it does allow is that the people that are going to be making the decisions for you are, in effect, they're not having to make the decision. They're simply being your voice. They are putting into action the instructions that you have already put down. And so nobody is going to your wife or your husband and saying, do you want them to be resuscitated? Really, the question then becomes, did he or she want to be resuscitated? And the person that is the medical power of attorney is only acting as your voice. And it's not this burden upon them to decide whether or not you get life-sustaining treatment. So by having these documents in place, it's a gift that we give to the people that are going to have to be asked these questions. And it's a gift that we give ourselves because it gives us the ability to get as much healthcare as we want or as little healthcare as we want. And to get that at a time when we're not able to speak for ourselves. And so I encourage everybody to please get one of these forms. There's a document called 5 Wishes that it's very easy to fill out, and it includes things like where you want your ashes spread, do you want to be cremated versus buried, and it includes naming a power of attorney and writing out a living will. And it's easy to get through, but there's others, such as this next page, that you can download and you can print up, you can handwrite something. It just has to be signed, dated, and witnessed. And I hope that you guys will, take a few minutes and do that. I can't stress enough how important it is. Again, my name's Nicole. I am the nurse practitioner over at TMC Hospice, and thank you for giving me the time today to talk about advanced directives and living wills and medical power of attorney. Thank you.
So thank you so much, Nicole. So I have a couple of questions, actually, and I did want to mention we do have the 5 wishes here. Over at TMC for Seniors. So if anyone is interested in receiving a copy, you can definitely reach out to us and we can make arrangements to get that to you. And we do make appointments here. We have somebody who will do a one-on-one appointment to help walk you through these forms.
Oh, fantastic.
Confusing. So that's that's another piece that I think is really important. I know sometimes people just have questions or they're just really unsure when they're looking at it. I had a question for you. I wanted to also show the life care planning packet, which we have here as well, and that's from the Arizona Secretary of State. And my question is more about the orange form on here.
Okay.
So we do have the orange form that is in the back of this. Can you sort of explain how the orange form is used? Because I think there's always a lot of confusion about the orange form.
There is a lot of confusion. So the orange form is known as the Prehospital Medical Directive. So in the event that you would want to be allowed a natural death, you should be given this orange form to fill out. It has space for a picture in case you live in a congregate setting, such as an adult care home or an assisted living. It has the phone number of your provider. It has information about whether or not you're on a hospice. But it states that in the event that your heart or lungs should stop, you would not want CPR. You would not want to have someone shock your heart to try to restart it. You would not want to be placed on a ventilator or get medications to try to restart your heart. And essentially it follows the individual or the principal wherever they go. So if they go to the hospital, it follows them to the hospital. If they go to hospice, it follows them to hospice. And it gives providers or even transport personnel, ambulance personnel, paramedics, it gives them the legal right to not resuscitate you if they should find you in a situation where in any other time they would call the ambulance and get you resuscitated. So it essentially is legal coverage, and it's on a bright orange piece of paper so that people can see it, and it's obvious that hypothetically, if you fall at your assisted living and you knock yourself unconscious, the paramedics aren't going to come and just grab you up and try to resuscitate you and get you to the hospital. So that's one reason why it's called the pre-hospital, pre-hospital. I'm just drawing a blank.
Directive, yeah.
Yeah, so it just follows you. So it's your shortcut for being sort of a DNR, and it's so that, or do not resuscitate, and it's so that personnel, whether it's a staff member at the facility or a paramedic, know that you are indeed a do not resuscitate or an allow natural death.
So really, and it's really just for when you're in the community as opposed to being in the hospital. Is that
correct? Correct.
Yeah. Okay.
And in fact, they make them in about a driver's license size piece of paper as well that some people choose to put in their wallets. So it's just something that you have on your person or at your facility. It's not, if you are in the hospital, it goes with you there, but it just goes in your file. So that when you get transported back home or to rehab, it'll follow you there as well.
Okay. So I had another question come in about the surrogate decision maker, how those assignments are made to avoid any kind of elder abuse. Is there anything that?
There's not, unfortunately. You know, we have had scenarios where it gets, there's not a medical power of attorney in place. It defaults to the children. There are 3 children. One of them may or may not have had like an APS report, or the siblings disagree on the whether or not one of the children is exploiting the parent, whether it's financial or abuse or physical abuse. But without legal charges, or without that person actually having been charged with that, that doesn't get taken into account. We have to get the majority of the children to agree on what the decision is going to be, whether it's for hospice or whether it's for aggressive pain medicine versus modest pain medicine. So once, within the world of hospice, once a patient is on service, if we suspect that there's abuse going on or exploitation, we're required by law to notify Adult Protective Services. But it doesn't change who gets to make those decisions. And but that is one reason why when you get your living will or healthcare power of attorney witnessed, that it shouldn't be a family member or somebody that has a vested interest in whether you die sooner versus later, just to protect you from someone having their own agenda.
Right. Okay, great. So I do want to just mention once more, if you are interested in an appointment to complete your advance directives, please give us a call in the office. The phone number is 520-324-1960. And like I said, we have tons of 5 wishes here, along with the life care planning packet, because we do like to give people a choice in what they prefer, because there is a little more detail, of course, as you mentioned, in the 5 wishes. Can you tell us a little bit on the POST? I know POST is pretty new in Arizona. Is it, does that sort of trump anything if you already had some sort of an advance directive in place?
It actually sort of works in complement to it. So your advance directive may say, if I have a life-limiting illness, I want the only medications I want would be pain medication or something for, anxiety. The PULSE, the physician's orders for life-sustaining treatment, can actually sort of specifically say, I want morphine 2 to 4 milligrams every 2 hours. So it's actually written as physician's orders. I want to be turned every 2 hours. I want to be taken off my diabetic diet. I want to be allowed to have a glass of wine a night, and then I want morphine. And so it's actually unique orders that's written out almost like your order set that the hospitalist at the hospital would write for you, and has a lot more detail. So it sort of complements your living will, and it's for the physicians to follow through with, not for your healthcare power of attorney. Certainly your healthcare power of attorney can say she has this pulse or he has this pulse that says she wants to be comfortable, but then it's for the physicians at the hospital to follow those orders that you have established with the provider that you had sign it.
Okay, great. And what about the mental health care power of attorney? Because I know that is different in every state, of course, but for Arizona, we do have a separate.
We do. We have a separate document. It can fall under one of 2 documents. It can fall under what's called the mental health care power of attorney, or it can fall under durable health care power of attorney if you include it as a separate category. So a durable power of attorney is a power of attorney that would include financial power of attorney, healthcare power of attorney, mental health care power of attorney. And those come into play in the event that mental health care power of attorney, that a person has advanced dementia, advanced neurodegenerative disease where they are unable to make decisions, or if they have such advanced mental illness that they are incapable of understanding cause and effect and not and making appropriate decisions. It doesn't necessarily mean it has to be a good decision. People have a legal right to make bad decisions. It just means that they have the capacity to understand the consequences of their decisions and to be accepting of that. So if someone is unable to, doesn't have capacity, or if they have advanced dementia, then the mental health care power of attorney assigns someone the right to make healthcare decisions for them. And that can include whether or not to have them put in a facility, put into a psychiatric unit versus a memory care unit, and what medications to receive.
Okay, so that's definitely another important piece to, I think, consider, that not everyone, it's not always done. And I know, because we have the 2, but if they don't fill that one out, that may cause you some issues, I guess, down the road, right?
It can.
Yeah. Okay. Thank you.
You're welcome.
Good. So that's all the questions I have today. I want to thank you so much for being here, Nicole. This was wonderful information, and I hope that everyone is able to take advantage of it. And please feel free to give us a call. and if you would like some more information on advanced directives. We do have another presentation coming up tomorrow. So tomorrow we are going to be seeing Fran West. She is with Center for Neurosciences. She is a nurse practitioner as well. And she is going to be doing As the World Turns, Dizziness and Vertigo. So we will be here at 2 p.m. tomorrow. If you are interested, please feel free to give us a call in the office and we'd be happy to register you. Again, the number here is 324-1960. Thank you all.
Thank you.